am Barbara Madsen, and I currently sit on the Washington Supreme Court, and I'm the Chief Justice of the Supreme Court. You will be pleased to know that there are 6 of the 9 members of the Supreme Court of Washington who are women.
Yes.
Of course, it wasn't always that way. I think because this is an election year and we have heard so much out there in the political realm, I thought I would address the question that I am asked very frequently, which is, why on earth do we elect judges? And I don't have a great answer, but I have a historical answer. And so I thought I would like to start by talking a little bit about the history of our state and why we elect judges, and then talk a little bit about what the court does and perhaps tie that into some of the recent decisions that we've made. So back in the 1800s, of course, we were a territory, the territory of Washington. And at that time, of course, judges were appointed by Washington, D.C., the Congress appointed territorial judges. And territorial judges did not enjoy a good reputation. And it was probably deserved. There were 3 divisions of our state territorial court, and 3 judges rode the circuit and decided cases for the territory. During the time of the territory, which ran from about 1854 to 1889, there were probably somewhere about 23 judges. But famously, 7 of them left the territory during that time without telling anybody they were leaving. One judge spent an entire year drunk and couldn't hear cases. So the problem from the territorial citizens with this problem was that they had no say in how judges were sent to them. They were not consulted by Congress, and so they got whatever Congress sent them. Mostly they were not people from the territory. They were people from out of the territory, and there was really no way for the local territorial citizens to have an impact on their courts. So fast forward to 1889, when our founding fathers and mothers were drafting our state constitution. This was also, of course, 1889, when the country was really in the throes of Jacksonian democracy, and the idea of Jacksonian democracy being as much direct democracy as possible. And so with the experience of these appointed judges, some of whom, of course, spent the year drunk or didn't stay in the territory for their own reasons, and the progressive era of accountability and citizen input really converged to result in our Constitution adopting an elective system of judicial officers. So our Constitution provides for the election of judges and justices. Of course, at that time, we had only Superior Court judges, and we had a Supreme Court that was organized under the Constitution. At that time, when we started with our judicial branch, we had 5 justices on our Supreme Court. But that grew quickly to 7, then finally to 9, and we are still at 9 justices today. And I think as I do this, as I study our history and the influences that were present in our state at that time, the 9 really, I think, represents the interest of our community at that time, and probably still today, in having power not concentrated in a few, but diffused to many. And this was, I think, our founders' belief that there was accountability when there were many voices, and with the election of judges, even more accountability. You probably, those of you who know much about Washington state history, know that we elect almost every person who holds office in our state, from the sewer district to the port district to every state office, our natural resources director, and so on. So accountability was a theme that really ran through the minds of our founding fathers and mothers. I say mothers, even though we didn't really have a right to vote. I think we had an influence. My sense is we did. And so we have elected our judges, but at the time of the Constitution, we also elected our justices through a partisan process. So one had to be a Democrat or a Republican to be able to stand for election for judge. At that time, interestingly, of course, we were pretty close to the Civil War, 1889. The war had been over for 20 years or so. And so the parties were different, right? So maybe they're not. I hate to be political, but the Republican Party at that time dominated Washington State, and that was the party of Lincoln. And the Democrats were in the minority at that time, and so the Democrats rallied their supporters to have the election of judges be nonpartisan. But the Republican Party in Washington at that time saw that as an attempt by the minority to take power on the bench, because at that time, you probably know from your history that the railroads were coming through the territory and into our state, and there was a great deal of corruption with regard to the legislature and the railroad moguls' relationships. And many people at the time, you see the editorial cartoons, you see legislators in the pocket of the railroads. And so there was a great deal of fear that the legislature would really not be responding to the will of the people, so they were relying on judges to do that. They wanted judges who were not corrupt, judges who could even out the balance of power between the legislature and, of course, the railroads that seemed to dominate, and the rights of the people in this new state. So the election of judges really served a purpose at that time. Fast forward to 1930, when the Bar Act was passed in our state. We didn't have a Bar Act until 1930, but in the 1930s was when we stopped electing our judges on a partisan basis. So now our judges in Washington are elected as nonpartisans. Interestingly, we have stayed with this configuration since then until more recently, when we had a bill that was introduced into the legislature in the last session, which would have reinstituted partisan races for Supreme Court justices, with a preamble saying, well, they already seem to be political, and so let's just have them declare their parties. So up until recently, the courts have been literally untouched until, as I say, recently, when there's been a number of attempts to reduce the size of our court from 9 to 7, from 9 to 5. One of the bills that would have reduced our court to 5 suggested that of course, we sit in the Temple of Justice, and so the bill required that the justices stand on the temple steps and draw straws to see who would be the 5 who would be continuing as justices of the Supreme Court. We've had proposals to have our justices selected by districts rather than statewide, and that is an attempt to bring geographical diversity, as I am told, motivates that legislation. That has not taken hold, and so today we still are electing our judges as nonpartisans, and we are electing our judges statewide. So every person in Washington has an opportunity to help to select their Supreme Court justices. I tend to agree that it's a good thing. The structure of our court system, many people don't understand how our courts in Washington work, and that's understandable because we do not have a centralized court system. We have a decentralized system in which the power of the court lies in the community in which it resides. So the funding for our county courts comes from county sources. The funding for our municipal courts comes from our city sources, and it's only the appellate courts that get state funding. So many of the decisions that are critical to a court are made at a local level. This causes some lack of uniformity, as you might imagine, across our system. You go to some counties that are wealthier counties, and they have many resources that they can use to support their courts. Judges in some counties are able to institute drug courts. Other counties are not so well-to-do, can't afford the drug court system, for example. And this is only an example of one of many resources that courts can choose on an individual basis to institute in their communities. And so we have a lack of uniformity across our justice system, and this is a challenge for justice in the state of Washington. In order to try to ameliorate some of that impact, the legislature in the 1950s created the Office of the Administrator of the Courts. And it started out with only 2 people in 1958, I believe. Today it's grown to about 200. Sounds like a lot of folks, and it is. What have they taken on, though? They have taken on the responsibility to bring whatever unity there really is in our court system, and that includes a uniform technology, uniformity of pattern forms that we use in our courts, uniformity of education. We do judicial education through the Administrative Office of the Courts, and so on. So to the extent we have uniformity across our state, it really comes as a result of having an Office of the Administrator of the Courts. So we are actually quite fortunate, given that if we were left to our own devices, any courtroom you walked into, the court could set its own rules. And we have at least made an effort to reduce the likelihood that justice in your county here, for example, is wildly different than justice in perhaps Spokane or some other area of our state. So I wanted to turn to the Supreme Court because as you have been reading, no doubt, we are in the headlines frequently based upon some of the decisions that we've reached. And so I wanted to explain a little bit how the process works and how cases get to the Supreme Court. Prior to 1969, all cases on appeal came to the Supreme Court directly. And that's because under our state constitution, there's an automatic right to appeal in every case. Our population in Washington really started to take off in the 1950s, and the court soon became overwhelmed by the number of appeals that were being brought. And even with 9, it's a little rough to keep up with that kind of volume. And so the court began sitting in departments, and there were, of course, 9 justices, so 4 would sit in one department, 4 in the other, and the chief would be the swing vote in each department, or would serve in each department, may or may not be the swing vote, but would constitute then five members. And so that's how we sat until 1969. In 1969, we instituted the Court of Appeals. That was a constitutional amendment that created the Court of Appeals. And so that relieved the Supreme Court of the daily fare, if you will, of the run-of-the-mill cases that came up on appeal. Many cases present the same issues. They've been resolved, and there's really nothing more to say about the law in that particular case. And so those cases remain at the Court of Appeals. They have to be heard, they have to be judged on their facts, their individual merits, but they're not making new law. The law is settled in a lot of areas. So this leaves the Supreme Court with the opportunity to take the really hard cases. Now I say opportunity because you always want to think in the positive. And one of our criteria, in fact, probably the most important criteria for accepting review by the Supreme Court is the significance of the issue. So cases that present issues of statewide significance are prime for being accepted for review by our Supreme Court. And this leads us then to have cases which of course have great import in our community, and issues that have great import generally have a political aspect to them. And this, of course, is democracy at work. I want to focus, I guess, just for a moment on a couple of the most recent cases which have been probably among the most controversial. And how did they get to the Supreme Court? So the first case that I wanted to mention was the McCleary case, the education case. We have a rather unique constitution which provides that the paramount duty, and it's the only time the word paramount is used in the Constitution, the paramount duty of the state to to provide an ample education for the children within the borders of the state. This provision of the Constitution was at issue in a case in 1978. It was the Seattle School District case, and in that case, the Supreme Court ruled that the state was not providing for the ample education of the children of Washington, ordered the legislature to define what a basic education what constituted a basic education, and then left the legislature to its own devices to pass such legislation and to implement that legislation. Fast forward to 2012, well, actually, it was probably about 2010 when the McCleary family filed a lawsuit complaining that, once again, basic education was not being provided to the children of Washington, and they brought a lawsuit in King County Superior Court along with some other plaintiffs. The case was heard by a trial court judge, and the trial court judge ruled that indeed the state was not meeting its constitutional responsibility to provide for an ample education. And so that was appealed to the Supreme Court. We could have sent it to the Court of Appeals, but no, under our criteria, this was significant. And so the court took direct review of the case, and we affirmed the trial court in its finding that education was not being provided, a basic education as was required by the Constitution. And at that time, we had a decision to make about whether or not to maintain jurisdiction over the case until the implementation of the legislature's attempt to define basic education was fully completed. We could have done what we did in 1978, but instead, the court decided that it was time for the court to hold the state responsible for its constitutional duties. And so kept the jurisdiction over the case, and it continues today to have, the court continues today to have jurisdiction over the case. This has resulted in a lot of public debate, and I actually think it's pretty healthy to talk about what is the role of the court, what are the roles of the various branches of government with respect to the Constitution. So it's really, I think, raised the profile not only of education as a paramount duty of the state, but also as to how the branches of government interact with one another. And I think that the legislature has made some very important decisions about what its role is in regard to the Constitution, as has the court. The court feels that the only way to fulfill the promise of the Constitution, to have the right of redress against your government, is to ensure that when courts make judgments, that those judgments are adhered to by the parties against whom the judgment was taken. So if you think about a case that you bring against your neighbor, and if you win your lawsuit, you have an expectation that the court will enforce the judgment that it reaches. And that is what the court has done in the McCleary decision. Each of the branches of government has a responsibility under the Constitution, and I think this is such an amazing example of how we are checks and balances on one another, and how, when you talk about the concept of the separation of powers, how each of the branches necessarily will bump up against each other, and that there will have to be an understanding of each branch as to how far it can go in fulfilling its responsibilities, and also doing introspection, looking in the mirror to see what is the responsibility and role of my branch of government, whether it's the court, the legislature, or the executive branch. The other interesting case, which I think points to some unique factors, or I guess unique circumstances in the state of Washington, is that we have an initiative process, and initiative I-1366 was recently decided in our state. I wrote the opinion in that case. Again, it came up out of the trial court. It was challenged as a violation of our Constitution, which provides you cannot have more than two subjects in one bill. And it was challenged on that basis. This is the Iman initiative, which would have required the legislature to pass a constitutional amendment changing the requirement for passing tax legislation from a majority vote to a 2/3 majority vote in order to pass any tax measures. And if the legislature did not amend the Constitution, then the sales tax would be reduced on April 15th of 2015 by 0.5%, I believe. So this was the gravamen of the initiative. We took that up twice. We took it up whether or not it could go on the ballot, and then whether or not it withstood constitutional scrutiny. We found it did not pass constitutional scrutiny. So now it's back in the legislature's court. they can adopt a constitutional amendment if they choose to do so. It would then go to the people for a vote, and the Constitution could be changed. Interesting, again, an example of how the branches work together. We have the people acting in the legislative capacity when they pass an initiative, the court in its judicial role when it evaluates the challenges to the initiative, and then the legislative and executive roles to decide whether or not, if they believe this is good policy, will they, despite the initiative not being constitutionally sufficient, instead pass this change in the law through the legislative process and then back out to the people. These cases, I think I chose them because they're high profile. You can see how they have political overtones. I'm certainly hearing about it as I go out and am campaigning for re-election. And people are very, they have a very strong view. Many people have very strong views about how, whether these are good policies and how the courts ought to proceed. So it's an opportunity both to talk about the issues, but also to talk, as I said, about the roles of the respective branches of government. And I feel very proud of the court's response to its role. I think we have been very measured, and we have carried out the role of the courts in the way that we believe the roles were intended under our state constitution. So I did want to speak a little bit about the court processes beyond just deciding cases, because this is where my passion is. When I started, I should say, my career, I never had any vision of myself as the Chief Justice or even a Justice of the Supreme Court. That was not my trajectory. And part of that, I'd like to tell the girls from the Trek camp, part of the reason I never saw myself that way was because I'd never seen a woman judge. So it's really about role models, and it's really about having the opportunity to be exposed to the possibilities that are out there. My first time in court, I graduated from law school in 1977, and I was assigned to Seattle Municipal Court as a defense attorney. And I walked into a courtroom, and there was a woman sitting on the bench, and I almost walked out thinking there was a mistake. How could there be a woman on the bench? So that was how my trajectory was shaped. I knew I could be a lawyer, though I was only one of 10 women in my class of 100, and some of the women dropped out. But I knew I could be a lawyer because there I was in law school, and I was able to pass the bar, so sure I could be a lawyer. But I never imagined that I could ever be a judge. It wasn't even on my radar. So I did practice law as a defense attorney. At that time, it was in the 1970s, and I found myself more frequently having to defend people who were accused of what now we think of as domestic violence. At that time, there was no name for it. There was no law that precluded domestic violence. It was, if there was an event that occurred between a man and a woman in a marriage, it was considered a family matter. And if at all, if there were serious injuries, perhaps there might be an assault charge that was brought, but there was no such thing as domestic violence, at least not, it wasn't named that. And I defended cases of domestic violence. The strangest things would come out in the testimony. One of my clients that I represented, his wife came in and said she backed into his knife. So you had some really interesting revelations about human anatomy and ability to be stabbed. But fast forward, I really became concerned about the role of women in these cases, because very frequently the judges would just dismiss the cases and say, well, that's just private matter, and we don't need to be involved. And if you did go to court and you did have a trial, the juries would say, well, that's a private matter. We don't get involved. And so things needed to change. I then went on to become a prosecutor. And the reason I became a prosecutor was that I was offered a chance to be a special prosecutor and to form a child abuse unit in the very newly created domestic violence unit at the city of Seattle. And I took that opportunity, and I learned so much that I had never known about family dynamics and the dynamics of domestic violence. it really captured my, my imagination. I thought so much could be done, so much more could be done to protect families and in particular women from what we saw as, I began to think at one time that perhaps there was domestic violence in every home in America. I'm sure that's not true, but it felt that way at the time. So I was very happy doing that work, and then I was offered an opportunity to be a judge, and I became the domestic violence judge, and I started a roundtable in our community that brought all the stakeholders together, and we really worked on streamlining the process for victims of domestic violence, making sure that their experience was not more damaging than the initial incident was to these families and to these women. Then 1992, and this is really the turning point for me. Again, I never saw myself on the Supreme Court, but in 1992, the Clarence Thomas confirmation hearings, Clarence Thomas, for those girls in the audience who maybe are too young to know, Clarence Thomas is a member of the United States Supreme Court. And in 1992, there were confirmation hearings that were being held in Congress to determine whether he would be appointed to the Supreme Court. And a woman by the name of Anita Hill came forward and spoke about her experience being an employee of Clarence Thomas before he elevated to the bench. He was the director of the EEOC, which of course is supposed to look at employment discrimination cases and protect people from discrimination. And she alleged that he had, in fact, discriminated against her and made sexual advances that were unwanted by her. Watching the hearings, along with almost everybody else in America, I was appalled at the way that Anita Hill was treated during her testimony. She was treated as if she were the perpetrator of this and that Clarence Thomas was the victim. So I thought long and hard about what needed to happen in our country, that things needed to change for women, particularly women in the workplace. I could relate to what Anita Hill was saying because I'd had my own experiences when I was a young lawyer. Anything from having judges inappropriately make physical contact with me, asked me to take off my jacket so that they could observe my anatomy, and so on. So I could relate to the things that Anita Hill testified to, and I thought I needed to stand up and do something about it. And so I told my husband one night, we used to have date night every Wednesday, and we were in a taco restaurant, and I said, Donald, I'm running for the Supreme Court. And he just started laughing. But he's not laughing anymore, because I've been there now for 24 years, and I was very serious when I said it. I was very fortunate with my timing. Many women were elected in 1992, and it came to be known as the Year of the Woman. We may be having another Year of the Woman this year, who knows? But when I sought the position because I thought that the perspective of women was not being heard. It's not that women are more right or they're wrong, or that men are right or they're wrong. It was really a matter of perspective. And one of the early days on the Supreme Court that drove this home to me was I was the only one on the court who had children. I have 4 kids, and my youngest was a year old. And we were conferencing late into the day, and I said passingly, well, looks like this is a Happy Meal night. And I got blank stares. A small thing, but it really is a perspective that needed to be heard. I was only the 3rd woman to ever serve on the court, and I was the only woman, of course, who had children, small children. The other woman who was there at the same time as I was Barbara Durham, and she had not had children, so it was kind of a perspective, but I really felt it was more about being a woman and the experiences that I had as a woman in the workplace, a woman in a profession that was male-dominated, as many professions were, other than perhaps education. Even there, I think, at the higher echelons, dominated by males. So I saw this as an opportunity to bring a woman's perspective and a mother's perspective. So over the past 24 years, as a result of what motivated me to come to the court, we have created several commissions through the Supreme Court's authority. One of those commissions is the Gender and Justice Commission. And I have been the chair of the Gender and Justice Commission since 1998. In the early 1980s, there was an organization that was known as NOW. It's now called Legal Momentum. But in the 1980s, they recognized, this was a group of women lawyers, they recognized that gender bias was never going to become a legitimate part of judicial training. And so they decided to form a curriculum around gender bias. That really took off. Between 1980 and 1987, 20 different states had launched their own gender and justice task forces to look at gender bias in our courts. And in our state, we did the same. In 1987, we had a task force that was formed, and it completed its work in 1989, looking at issues, the most broad issues, really. For example, how do you value a woman's work when she is the victim of a personal injury? So you have to compensate her for her lack of ability to earn. We minimized a woman's role and the work that women do in the judgments that were being rendered by juries because they devalued women's work. Also, distribution in marital dissolution. You know, what's a fair distribution based upon what she has brought to the relationship? All of these issues showed gender bias, including the parenting decisions, whether or not in a dissolution a man or a woman were to get custody or primary care of the child. So many issues we saw were at play in our justice system. And in 1995, one of the recommendations from the task force, there were 56 pages and over 100 recommendations. One was to establish a Gender and Justice Commission under the authority of the Supreme Court. And we did that, and we have been, ever since, working to rid our justice system of gender bias. We're sort of working hard. I'm getting close to the time that I need to wrap up, so there will be questions. But I just want to highlight a couple of things that we have accomplished, which I think are rather groundbreaking throughout the country. One project was to prohibit the shackling of women during labor and delivery. If you can believe, we shackle women during labor and delivery who are women who are in prison or jail. And so we ran a bill in partnership with a number of other organizations in the state, and we were able to ban the shackling of women during labor and delivery. My son, when I told him about this, he said, why would they chain them down? Who would want to run away when she's having a baby? So, he didn't get it, and neither did we. Another was the horrible shooting in Tacoma by the chief of police of the Tacoma Police Department. He shot his wife. There had been domestic violence in their relationship for years. Killed her in front of their two children. Then turned a gun on himself. But for many years, she had tried to get help for the domestic violence that she was suffering. But because he was the chief of police, there was no investigation. And so what we were successful in doing is requiring by legislation every police department and law enforcement agency in our state to have a police-perpetrated domestic violence protocol for investigation. So whenever there is a police-perpetrated allegation, they have to have a special protocol for investigating that claim. And we recently did a public records request, and every law enforcement agency has, in fact, adopted such a protocol. So more protection for victims of domestic violence. And then our prison project. Many women are incarcerated. They don't have access to domestic violence treatment. They have a very difficult time accessing the court system because they are not allowed to use the computers in the way that we are. They're not able to get to court. They lose their children. And we've recently started a kiosk project which allows women to get temporary orders and to be able to respond to court documents in respect to the custody of their children. So these are just a few of the highlights of our commission, but we continue to try to even level the playing field for women who are involved in our justice system. I so appreciate the chance to talk to you all. I said I had to cross out many pages because there's so much I'd love to share with you, but I did say I would leave time for questions and answers, and I'd be more than happy to do that. I can try and take them in the order I saw them. The lady back here.
Thank you, Your Honor. How are the district courts, is the Court of Appeal organized? Is it district courts geographical? And the second question is, does the Constitution or other law in Washington require the appointment of counsel on an appellate level for criminal appeal?
Can you repeat the question at all?
So the question was, how is the Court of Appeals organized? Are they in divisions or districts? And then is there a right to counsel if you're indigent and you are on appeal? Is there a right to counsel for those individuals? Thank you. I will answer the question. So the Court of Appeals is divided into 3 districts. Interestingly, it's been a very hard philosophical struggle for the Courts of Appeals to think of themselves as one, because they are one Court of Appeals, but they sit in 3 different locations. And they have jurisdiction over certain parts of the state, and they have to run for election in their district. And so that's how they're organized, and I think they're doing a remarkable job of beginning to coalesce and understand themselves as being one entity. They share a budget, they share rules, they share so much in terms of the work that they do, and now they're actually sharing cases. They've begun to share the workload across divisions, which I think is an extremely important step forward, because some divisions are more impacted by the cases than the other divisions. As to the right to counsel, there is a right to counsel for an indigent appellant if they are challenging a criminal conviction. There is a right to counsel. And then there was a question back here, I think in the gray sweatshirt, was it?
Yeah, so you're like a judge, right? So would you say you want to become president? Because there's like stuff going on where there's debates and stuff with them. And so who would you think would be best for it, even though there's not very good people?
I think the first question was, would I want to be president? Maybe when I'm daydreaming some other world, but I would say that's really not the direction that I've chosen for myself. I think it's a different challenge for a person running for a partisan position like the office of president. I am very comfortable writing my decisions in the Temple of Justice. As far as the kind of debates that we're having, I am so disappointed at the level of the debate that we're having in our country. I have been asked to debate my opponent. I have an opponent for my re-election, and as much as I find that challenging, it is all at a reasonable level. We talk about issues facing the courts. We talk about our judicial philosophies. But when you have to talk about your anatomy and your sexual habits, I find that to be beyond what I would be willing to do. So I don't think presidency is in my future. There was a hand over here.
Can you tell us about the issues in and the status of State versus Gregory?
Yes, you mentioned that earlier when we were talking, and so State versus Gregory is a case that is pending in front of the court. We've heard oral argument in the case. State versus Gregory is a death penalty case, so that is, it's an aggravated first-degree murder with special circumstances, which means it's eligible for the death sentence. And we heard arguments in the case, and the reason that it hasn't been issued, the opinion hasn't been issued, is that a different issue than we originally thought was involved in the case arose during the course of the arguments and and through the exchange of our briefs, the briefs of the parties. And that is a report that was prepared by Professor Beckett at the University of Washington. And she prepared a study about the racial impact of the death penalty in the state of Washington, whether there's racial disproportionality in the impact of the death penalty on communities of color, in particular African Americans. And so the state objected to the court's consideration of that research. And so the court has directed the commissioner of our court to work with the parties to ascertain the I guess, reliability of the study that was done, and to allow the state to have a response to that research, and then it will come back before the court. We're anticipating before the end of the year for the decisions by the commissioner, which will then have to be reviewed by the court. But it became an issue well into the arguments and the consideration of the case by the courts. And so if we had that understanding of that issue being so central to the case before we had oral argument, we probably would have asked for additional briefing and additional decisions to be made before the oral arguments were actually even set. But we did set the argument, we did hear the argument, and now we're waiting for this research really to be analyzed by both sides, to give both sides a fair opportunity to argue whether we should even consider the Beckett report. Thank you. Yes, over here.
Yeah, wait for the mic. Mom of 25 years in this community, and I was wondering. I'm a 4-H mom.
There it goes.
I'm a 4-H mom of 25 years in Jefferson County, and I know that there was an issue with the fair funding at one time with the McKinney-Vento was actually affected by because the Washington State Department of Agriculture also helps fund 4-H, and we were kind of cut back. And I know that decision is going to be happening here soon again, and I was just wondering, is it going to continue, because the fairs are the largest classroom for all these kids in the community and people on homeschool, to kind of their final game to show what they've learned and what they've done, and to show the community.
I can answer it in only one way, I guess, and because I'm not in the legislature and I don't decide funding. But I will say that the 2017 legislative session is going to be a very difficult session. We had legislation that was passed last session, the short session. They passed legislation that they would, during the 17-19 budget cycle, fix the problems with the education broadly, the public education system. Legislature passed legislation saying that they were promising to do that. If they do it, I don't even know, there's a variety of dollar figures that have been mentioned about what it would take to fix the problem with the uniform, ample education system for our public schools. And everyone who knows about the budget is expecting that that's going to dominate the discussion in the legislature. And what that means to other aspects of that require state funding, like fairs, like social safety nets, the programs that we have in our community for mental health, etc., how those are going to be impacted, if they're going to be impacted. I think that's all going to be a part of the discussion that the legislators engage in this upcoming session. It's not going to be an easy session, but that's why they are elected. They are elected to lead, and I hope they will.
One more.
Okay. Oh boy. How about Ruth? Is that you had your hand up? I thought.
I would like you to explain how a decision is made in your court. For instance, when the cases come to you, how do you decide who will write the opinion, and when the opinion is written or drafted, how do you decide who's going to sign and who's going to write a concurrence or who's going to write a dissent? How does that, what's the dynamic of decision making?
The court, of course, is a court of discretion. So at the beginning, before we've even accepted the case, we know what the case is about. We know what the issues that are being presented. We have a workup from our commissioner's office on the primary issues and then the primary cases that would resolve the issue. And so we start just from day one acquainting ourselves with the issues and the main cases that are going to be necessary to review in order to decide the case. We have three terms of court, and at the beginning of each term, we have a drawing to decide which judges are going to be responsible for presenting the case at the oral argument. And so we have such a scientific way of doing this. I reach into a hat and I pull out a name. And that starts the rotation. So if I pull out, whatever judge I pull out, we go in terms of seniority for the assignment of those cases. Now, in the United States Supreme Court, the Chief Justice has loads of power. The Chief Justice gets to decide who writes the opinions. In our court, it's coming out of a hat. And we don't have assignment pursuant to your expertise as a lawyer. For example, if you're a labor law lawyer, we don't give you the labor law cases. It's all random. And we think that's a healthy thing because it requires all of us to become specialists in all of these issues. And so once the case is drawn from the hat, it's set for an oral argument date during whatever term, so winter, fall, winter, and spring terms. And once it's set, then that Chambers has the responsibility for preparing a memo for the use by the rest of the court. And the memo is intended to set out the facts, the issues, and the resolution that justice would propose on solving the problems that are presented. So each of us then receives the briefs in the case. We can do independent research, looking at cases that perhaps weren't mentioned by the parties, legal treatises, cases from outside our jurisdiction. So maybe another court has grappled with this issue and they've done a good job of resolving it. So we borrow precedent rules all in judicial decision making. And so we do our own independent research. We read the memo that was prepared by the reporting justice. Come to the day of arguments, we hear pretty brief arguments, 20 minutes per side to argue. I was in Canada with the Supreme Court of Canada, and they said, 20 minutes? We give them half a day. I can't imagine. So 20 minutes per side. We hear three to four cases a day when we're hearing arguments during session. And following the arguments by counsel, we go back into our conference room. The judge who prepared the memo will stand. It's quite a formal process because these are big issues and you need to have some formality. And so the justice will recite the facts, the law, and their resolution of the issues. And then there are questions from the members of the court. We have a robust discussion around the issues. We sometimes agree entirely, and we have 9-0 decisions. Other times we're divided. We have a word for it, richly divided, and sometimes that richness, you wish you were poor. But then once the presentation is made, the questions are asked, I call for a dissenting view. If there is a dissenting view that's expressed, more questions from the dissenting or about the dissent's view, and then we vote, and we vote in seniority, and whoever gets the 5 votes that is necessary will get the opinion. That will be their assignment, and I assign to the reporting justice if that's the person whose view prevails, and as far as the dissent, I assign that to whoever spoke first. The new justices, we kind of hoodwink them into raising their hands and expressing dissent. If nobody raises their hand, it just goes around, and you know where you are in the round. So you kind of hope one of the new judges will raise their hand. Then it's the opinions are written, we circulate them, people decide what they're going to sign. Sometimes in the circulation process, we have people who want to write yet a different view, and they can write, anyone on the court can write a different view, and then that circulates as well. Quick story, back in the day before computers, there was an opinion, a majority that was circulating, and actually the original had to circulate because we didn't have computers to run off multiple copies. And one of the justices who'd written the opinion, the justice who had written the opinion went to the chief one day and said, that opinion seems to be nowhere. It's been 8 months. And the Chief Justice pulls open his drawer and says, "Oh, it's right here." Justice did not like that opinion. Thank you so much.